On this episode of the Case of the Mondays, we're going to talk about a scenario that happens very, very often in my office where somebody walks through the door and they've been involved in an automobile accident. Now, you guys should all know by now that you have to have three things to have a successful liability case when it comes to an auto accident. Number one is liability. It's somebody else's fault. Number two, damages. You'll need to be injured in that automobile accident. And number three, you're going to need insurance coverage. But wait, what happens if number one isn't so clear? Fast forward to a scenario that happens very often in my office where someone will come and tell me that they've been involved in an automobile accident and their neck, back, shoulder, knee, teeth are killing them. Well, good news is they're in the right place because I can get them to the best medical providers in South Florida. The next moment, they let me know that they have a copy of the short order form or the full police report. Upon reviewing that police report, something funny happens. The officer either doesn't assign a liability clearly to one party or the other, or the officer says that both parties may be at fault. Now, we're going back to that checklist of three things. Number one is liability, meaning someone else caused the accident. Now, that is always a very easy scenario, but life isn't easy and it's often in a gray area. So when we're talking about liability and split liability, that is something that you need to start preparing for right at the scene of the accident. Now, how can you ensure that the determination is on the at-fault party and is done correctly? Well, the first thing that you can do is make sure that you don't move your vehicle. Obviously, if you're in the middle of the turnpike, get out of the way and get safe. Go ahead and take pictures of where the vehicles are and where they stopped. Now, the next thing is call the police. It's always important to have an independent third party come to the scene to investigate. That is why we have police officers, and although it might be an inconvenience or the other person is pleading for you not to call the officers because they don't want their insurance to go up, trust me, it's worth its time, weight, and gold to call the police to have them come out and do a report. Now, after you call the police, make sure again you're safe. But start to take pictures of damages to the vehicles. That will allow, at a later date, the determination of who caused the accident. And that's very important because we have to determine liability. Go ahead and take that bit of time before the officers come. And if there's any witnesses, see if they're willing to give you their name and contact information. Interesting story, we just had a case recently in my office where an independent witness came in and was willing to sign an affidavit stating clearly that the road conditions were dangerous, and our client actually won the case at mediation because a good Samaritan witness came in and gave an affidavit. So that information is incredibly important because oftentimes you won't really remember who that witness was. So get their name and definitely get their cell phone number. Another thing that you're going to want to do after the officer is there is take your time and explain your story thoroughly. If the officer seems to be in a rush, be calm, but be firm, and don't accept any liability, even if the officer tries to tell you that it's your fault. Once we get a copy of the police report, remember that police report can always be changed if things come up that the officer didn't know about. So please keep that in mind. Now, that you're safely away from the accident scene, you've calmed down, you're not as shaken, take 5 minutes to write out as best you can your statement and your thoughts as to how the accident occurred, time, place, speed, whatever details that you can remember at that very moment, write them down. Why is that? Because you may not be able to come in and see me for a day or two and your memory might be a little hazy. It's always going to be better immediately after the accident to remember those little details. And when it comes to disputed liability, those little details really, really matter. Now, after all that is said and done, you've probably already done the right thing by picking up the phone and calling me at 833-MIKE-24/7 or sending us a message on Instagram at Law Firm Florida. But if you haven't, now is the time to do so. Okay, good. Now that we've fast forwarded in time, due to the miracles of editing, we've now spoken about your case. And because you've done all of the right things, we are in the position to dispute liability. Now, remember, in the state of Florida, there is a legal theory called comparative negligence. So even at the end of the day, if a jury does not decide that that other person is 100% at fault, they still may find them a certain percentage at fault. And that could allow you to recover for your pain and suffering if you wouldn't have otherwise moved forward with the case. For all the tips that I've talked to you today about how to prepare yourself when liability isn't so clear after an accident. So thanks for hanging out with me again on another case of the Mondays.